Like that.
Court officer. Court officer. Court officer.
Are we audible from Gulbarga? Court officer? Sir, we are now audible ಇದೆವ್ರಿ ಕೇಳಿಸ್ ಬರ್ತಾ ಇದೆ
ಸರ್ ಹೇಳಿ ಸರ್
ಗುಲ್ಬರ್ಗ ಇಂದ ನಮ್ ಕೇಳಿಸ್ ಬರ್ತಾ ಇದೆ ಇಲ್ಲ ಆವಾಜ್ ಆರ್ ವಿ ಆಡಿಬಲ್
ಹೇಳಿ ಸರ್ ಸರ್ ರಿಪೀಟ್ ಮಾಡಿ
am I audible ನಮ್ ಮಾತು ಕೇಳಿಸ್
yes
ಬರ್ತಾ
sir yes sir certainly
sir court officer ಈ ಸೀರಿಯಲ್
ಕೇಳಿಸ್ತಾ ಇದೆ ತಮ್ಮ ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇದೆ ಸ್ಪಷ್ಟವಾಗಿ
ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಅಲ್ಲಿ ಒಂದು MFA ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿಂದ ಮೇಲ್ ಆಗಿರ್ಬೇಕು ಮೋಸ್ಟ್ಲಿ ಫ್ಯಾಕ್ಸ್ ಅಥವಾ ಮೇಲ್ MFA ನಂಬರ್ 200955
ಬಂದಿದೆ ಸರ್ ಬಂದಿದೆ
ಅದನ್ನ ರಿಲೈ ಮಾಡ್ತೀವಿ ಅದು ಹೇಳಿದಾಗ ಒಂದ್ ಸ್ವಲ್ಪ ಸಾಹೇಬ್ರಿಗೆ ಸಪ್ಲೈ ಮಾಡಿ
ಆಯ್ತು
ಇವಾಗ ಡಿಬಿ ಗುಲ್ಬರ್ಗದ ಎಲ್ಸರ್ ಓಕೆ ಡಿಬಿ ಗುಲ್ಬರ್ಗನೇ ಅಲ್ಲ ಇವಾಗ ತಗೊಳ್ತಾರೆ
ಹೌದು
ಬೇರೆ ಲಿಸ್ಟ್ ಇಲ್ಲ ಅಲ್ಲ
ಬೇರೆ ಇಲ್ಲ
ಓಕೆ ಥ್ಯಾಂಕ್
ಹಲೋ ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್
ಜಡ್ಜ್ಗಳವ್ರವ್ರು.
ಶಿವಾನಂದ್ ಪಾಟೀಲ್, ಹರ್ಷವರ್ಧನ್ ಪಾಟೀಲ್, ಇದು ಹೈಕೋರ್ಟ್ ಬೆಂಗಳೂರು, ಪೋರ್ಟಲ್ ನಂಬರ್ 19 ಬೆಂಗಳೂರು. ಇಲ್ಲಿ
ದೇವಿದಾಸ್ ಅಂತ ನಿಮ್ದು ಬಂದಿಲ್ಲಿನ
ಇನ್ನ ಯಾರ್ದಿ ಬಂದಿಲ್ಲ. 903885 ನಾ ಕುಂತಿದೆ. ಮೀಟಿಂಗ್ ಕೊಡಿದ್ರು ಫೋಟೋ ಬಂದಿಟ್ಟಿದ್ದೇನೆ.
ನೀವು ಎಂದ್ ಕುಂತೀರಿ?
ಈಗ ನನ್ನ ವಿಚಾರ ಇದು ಚಾಲು ಮಾಡ್ದ ಅಂದ್ರೆ ಫೋಟೋ ಬರ್ತದಲ್ಲಿ ಸ್ಕ್ರೀನ್
ಕೋರ್ಟ್ದಾಗ ಕುಂತೀರಂತ.
ಎಲ್ರಿ ಕೂಡಿ ಕುಂತೇ ಬರ್ತದೆ. ಒಂದು ಜಡ್ಜ್
ಅವರೇ ಜಡ್ಜ್.
ಹೇಮಲೇಖ
Haven't come.
ಕೃಷ್ಣಕುಮಾರ್.
They said they'll come. All right. Right. Mr. Sanjeev Kumar Patil.
ಲಕ್ಷ್ಮೀನಾರಾಯಣ ಆರ್ಗ್ಯುಮೆಂಟ್.
Mr. Sanjeev Kumar Patil, I can't hear you. We can't hear
Appellant,
you.
my lord, appealing for the appellant, my lord, now.
Some
my lord,
refund of.
my lord, in this,
My lord, appears for a refund.
my lord, yes, my lord, your lordship has
All right.
order for remand matter.
All right. We'll direct refund of court fee. Kodi. Registry to act. Kodi. Registry to refund the court fee in terms of section 64, 64 of the Karnataka court fees and refund the court fee paid on the memorandum of appeal in terms of section 64 of the Karnataka court fees and suits valuation act. Right. Registry to issue fresh certificate copy after carrying out necessary.
In both the case, my lord.
In both the cases, both separate orders, Mari. 1 and 1.1. Right. Sale number 2. Learned Advocate General. Limitation Act Kodi. Amele Pasa Land Acquisition Act. Right. Right. 60 plus 60. Not exceeding. That's right.
ಹಚ್ಕೊಂಡಿರ್ತಾನೆ
ಯಾರು?
ಏನಂತೆ
Kind of the management is working time. These aspects. I must disclose
Central amendment. 74 ಮಾಡಬಹುದಾ?
Yes, on Chandila.
some cases for the inquiry is either cases majority of the cases state is using of this kind of only this arbitration the kind of experiences we are having
No, arbitration act. No, in fact, I must tell you this one matter in Gulbarga, sugar factory matter. We tried our best to. We reserved it for about 2 months, and we thought it was dismissed on account of delay. Oh, it could have been dismissed in 2 minutes. Section 34 was dismissed on the ground of delay. but we everything physically possible we tried, but
Some cases, criminal cases.
but ಮಾಡ್ಕೊಳ್ಳಿ no
No,
difference.
I'm not, submission, no, I have one submission.
No, what I'm trying to say is,
No injustice.
will it,
I have one submission.
will it impact the amendment even if it is brought?
Likely, but at the same time, I do not want to so I have told them that you will deposit down. You want some of the post they can withdraw it. Not uncommon word on the question of termination of legal loss. But we will come back for a lot of months time and see. I have a draft maybe we will extensively discuss that. Have some delay from the existing.
In fact, that's what they wanted. They are all, in fact, they were pressing for withdrawal of a portion of the amount of. There is one more exit route. I don't know whether you thought about it. Or there's one exit route.
Yes, Muro.
File a review. The review there. I know the scope is limited. Section 14 will exclude the time spent here. If the review is rejected, then come back. Because for review, section 5 is applicable. I just told you because it's larger public interest. That's what we just discussed. That at least legally it is permissible. Whether 47 rule 1 error is a different. But that right. So for the present withdrawal from Shivanand Patil rule.
Yes, ma'am.
Yes, 50%.
50% of the amount.
50%. ಇಲ್ಲ ನೀವು ಇದ್ರಲ್ಲಿ ಯಾವ್ದ್ರಲ್ಲೂ ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಈ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಸೊ ಅದು ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ ವಿಡ್ರಾ. So
that is
That
already
portion 25, in fact, earlier 50% was awarded. Stay was granted subject to deposit of 50%. In some matters, it was only 25%. Then the division bench subsequently modified those 50% to also to 25%. And that 25% has already been deposited. They have taken the money.
Sir, Ade sir, the entire list of all the matters which are posted today is in front of us.
Yes, my lord.
Whatever they have deposited.
That we have already withdrawn, my lord. That has already been withdrawn.
Already withdrawn. Oh, okay. So that's right. So more than 50 lakhs or
More than 30 lakhs, 30%.
no. Lord, our request.
Less than 50 lakhs, less than 30 lakhs.
is this okay? Now, in these matters which are posted before us, there is no stay. There is no stay. So we'll have to stay subject to. Right. Stay subject to deposit of 30% if the compensation amount awarded by the reference court exceeds 50 lakhs, and 50 stay subject to 50% deposit if the compensation is less than 50 lakhs. Liberty is reserved. I mean, the claimants are entitled to withdraw the amount deposited.
That may not serve our purpose, my lord.
Firstly, my lord.
Firstly, 25% is already deposited by them. In addition to 25%,
Yes,
if
sir.
they want to deposit,
Sir,
fine.
one day, sir, let's understand this. So let us go one by one. Serial
Yes.
number 2.23 onwards.
Yes.
2.23 up to
29.
No, 2.23 up to 2.29. 2.81,
Yes.
right?
Yes.
2.23 to 2.81. Wherever the compensation is in excess of 50 lakhs, they will deposit 30%, which you can withdraw. Wherever the compensation is less than 50 lakhs, they will deposit 50%. For the
May I-
present,
May I make? As it is, they have already, the stay was subject to deposit of 25%.
there's a stay
already
ಕೊಟ್ಟಿಲ್ಲ ಅಂತಾರೆ. Sir, ಈ matters ಅಲ್ಲಿ stay ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿದ್ದಾರೆ
ಕೊಟ್ಬಿಟ್ಟು
25% ಡಿಪಾಸಿಟ್ ಮಾಡಿ ಅಂದ್ರೆ ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ.
ಒಂದೇ ನಿಮಿಷ. Let's see this. We didn't see this. That's what 25% is already deposited.
Yes, that is now what the states.
To do one thing, because of the that 25% of the award amount you have deposited across all appeals, 25% of another 25% you deposit.
Yes, fine.
Lord, we are agreeable for that.
Right.
In fact, Lord, in first,
So it has to be 5 across all these
25%
already deposited.
25% of the amount you have paid minus the amount is already deposited.
Since they are on VC, we can do one thing. I'll post it again next Friday, whenever. Next Friday, the half day. Some special sitting. Let them give. Can you give a calculation?
Lord, one request, my Lord, let there not be any discrimination based on the extent of land, because, my Lord, the larger the loser, Lord, let him get, my Lord, in proportion to what he has lost. Only because, my Lord, his amount is more.
Just work around that figure, and between 30 and 50, each case, that will take a little thing to do. Work out something, and only thing is, since that idea fell from us about the review, other independent of Markwari.
Nothing to this point is
Between 30 and 50, just work around whatever exactly you can do it, and give a calculation, and they'll give a calculation.
Lord, one request, my Lord, in one batch of cases which was heard first, Lord, that is item number 2.24, 2.23 onwards, where I have moved an application for, my Lord, interim direction. The interim order was subject to deposit of 50%. Since, my Lord, subsequently other matters came up, in those cases 25% was made. In my case also, my Lord, 25% was deposited. My request is this, my Lord. Yes.
Tell me one thing, 2.23 till 2.82.
Yes, my Lord.
In every one of these cases, it is 25%.
No, my Lord. Earlier, first 8 matters were 50%. In first 8 matters,
Already deposited. So let them check up.
Lord, I'll just clarify, my Lord. The order is, my Lord, for deposit of 50%. But in all cases, each and every,
We saw the order.
Yes,
The order seems to be 25%.
Your Lordships may kindly see, my Lord, 2.23. Your Lordships, my Lord, are holding, my Lord, I believe, the first in the list, item number 2. 2.23, one batch of cases, there was an order for deposit of 50%. Even in those cases also, they have deposited only 25% only. My Lord, they are, my Lord, all these claimants are treated now equally. They are given, my Lord.
Ashwardhan, just tell me one thing.
Yes.
Serial number 2, the first matter.
Yes.
The order says 25%.
Yes, my Lord.
Then two. Then we jump to 2.23.
Yes, my Lord.
So,
MFA number 202277.
Anode, this 202276 except one anta heltare.
7.
And that them give details. Okay.
Yes. Yes.
Now 25% of the award has been deposited.
Yes.
Starts from 2 and then continues from 2.23 till 2.82 na.
Yes. Insofar as deposit is concerned, my Lord, There is except for one case, all cases, my lord, they have deposited only 25%. In all
Right.
cases, we have withdrawn 25%. There is no dispute regarding that. We are asking that, Lord, this deposit and withdrawal of only 25% is wrong. Your lordship may kindly
You
make it
can hear, Allah?
50%.
You can hear them. Okay, I will just, in addition to that, you want 25% more in all cases.
Yes, but if my lord, because one thing is, my lord, this issue will not be separated, my lord, in any time, my lord, soon, if that is the, my lord, the proposition or the intent to amend or whatever it is. My lord, in that context, my lord, we will lose the right to buy similar property in the vicinity of so what we are seeking is, my lord, lordships can hear, if your lordships can hear this, my lord, on merit also, my lord, they are proposing as if it's a, my lord, very exorbitant compensation that is awarded. That's
No, for the present,
the present, if 50% is made, my lord, and that is, my lord, permitted.
they'll try to reach 50% in as many cases as possible. In as many cases as possible. That's what they are saying. See, ultimately it is, see, you are asking for 50%, but it again, we as the court will have to use some discretion to find some via media, right?
Yes, Lord, my only request would be, let there not be any discrimination between the claimants, because, my lord, person
So
who
that
is
they're saying that we understand,
more.
but ultimately, if they were to say that they will deposit X amount, supposing they were to say that,
Yes.
look, this 30 lakhs is there, therefore we are ready to deposit 50%, and therefore more than that, please exercise your discretion and ask us to deposit a little less. Now, for us to say that across all awards, irrespective of the amount, they have to pay, we'll have to provide reasons, right?
No, my lord, as a percentage of, my lord, the award.
Harshvardhan, for us to reject their contention that irrespective of the amount, they have to deposit 50% as claimed by you, we'll have to assign reasons. Then we'll have to assign reasons as to why we're rejecting their contention that irrespective of the amount, they have to deposit 50%. So it's basically discretionary. What they are saying is, depending on the amount, we'll work out somewhere between 30 and 50, come as close to 50 as possible and give the details. Once they give the details, then you look at it, then we'll arrive at some figure, so that otherwise, what do we do?
Because my lord,
Sir, I understand, sir. We understand.
But capping at 30 lakhs, my lord, where he wants to, my lord, deposit on the higher side.
That's why I explained to you in detail.
Very few matters, my lord, in that category. Because the extent of land lost is much higher.
See, as you know, whether it is in a money suit or a commercial appeal or a MFA, larger the amount, courts are inclined to direct lesser deposit. Isn't that how discretion is exercised?
Yes.
Therefore, let them work out something. Let them work out something and come up. To say a blanket 50% irrespective of, we have to give reasons, right? When they are saying that, yes, we will deposit, sir, we'll deposit, give us a little.
Yes.
In fact, some cases people say deposit 100% also. So it depends on facts of each case. ಅವಾಗ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ನಮಗೆ ಪ್ರತಿಯೊಂದು ಕೇಸು ತಗೊಂಡು ಅಮೌಂಟ್ ಎಷ್ಟು ಅಂತ ಹೇಳಿ ಅದಕ್ಕೆ why they are saying 50%, they are saying 30%, you are saying 50% ಅಂತ ಒಂದೊಂದೇ ಸೆಪರೇಟ್ ಆರ್ಡರ್ಸ್ ಬರೀತಾ ಕೂತ್ಕೋಬೇಕಾಗುತ್ತೆ. So they try to reach as much as possible. They try to reach 50% in as many cases as possible or close to 50%.
Lord, one request.
The new act seems to have made it more problematic. Allah? Right. Heli, you judicial order adre, or they'll give a proposal, then according to you, 50% has to be granted. Then you'll have to leave it to our discretion. ನೋಡ್ಕೊಂಡು ನಾವು ಪ್ರತಿಯೊಂದಲ್ಲೂ ಸೆಪರೇಟ್ ಆರ್ಡರ್ಸ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ ಅಥವಾ ಅವ್ರ ಪ್ರಪೋಸಲ್ ಒಪ್ಕೊಂಡು ಸದ್ಯಕ್ಕೆ ಮಾಡಿದ್ರೆ then we can solve it in one shot ಅಷ್ಟೇ. Today right now for us to pass an order saying 50% is not possible because ಪ್ರತಿಯೊಂದು ಕೇಸು ತಗೋಬೇಕು, ಅಮೌಂಟ್ ಎಷ್ಟು ಹೇಳಬೇಕು, ಅದೇ ಬರಿಬೇಕಾಗುತ್ತೆ.
Our argument is like this. when the AG is putting a cap on 30%, extendable up to 50%, varying from claimants to claimants.
Correct.
That makes the difference that there is discrimination. It will be also difficult to.
Sir, it is not the final order, sir.
It's
only for, sir, it's only for the purpose of.
For that reason, if your lordship. For that reason, my lord, if your lordship is prepared to accept 50%, and if AG has any apprehensions, we will give an indemnity bond that will return back the amount if this amount is.
So it doesn't work there. Sir, farmers have the indemnity bond.
Because 8 years along, we are still to receive the compensation. 8 years now.
Okay, sir, we are trying to think of some win-win situation for all. Let them give a proposal. Let them. They'll give a proposal, sir, so that at least. What can we? Otherwise, we'll have to take up each matter now, and each matter for us to take up now and record the reasons, say what is said in the affidavit. It takes a lot of time.
My lord, if I may suggest something, my lord, there are certain appeals, my lord, filed by me in time, my lord. If they are considered, if the AG has, my lord, the apprehension regarding the quantum, he can, my lord, argue there also, my lord. If the quantum is proper, my lord, there is no purpose in, my lord, keeping this, my lord, pending on the count of either, my lord, the question of law or otherwise. Because there are some appeals, my lord, on merit. Let him also address on merit, my lord, because it's a very reasonable.
See, for this bench to assemble and to get a date fixed, there are now, after the next roster, I for sure will not come to Gulbarga. Because I already come. Now, madam, I don't know. Whether I'll go to Dharwad, I'll remain here.
We will come, my lord, if it's not convenient date for AG.
We'll try. Because the problem is, last time, see, all of I think at book tickets and everything.
Yes, my lord. Last
before that, we understand.
That was communicated.
For us to keep this matter for final hearing, it's physically impossible. We can't hear it like this. Not possible because both of us are in different combinations.
My lord, we will make it to Bangalore. Not any
one is the lagalari. Main appeals not possible. And our goal here argument agbekalai. Adike via media at least ದುಡ್ಡು ತಗೊಳ್ಳಿ ಇವಾಗ. Extra other than whatever you have got, take the money and argue the main matter before the regular bench. Sir, one option. Second ಇನ್ನೊಂದು option ಕೊಡ್ತೀನಿ. Think about it. We'll release it right now and post before the regular bench in Gulbarga next week itself. You sort it out.
Madam, we have gone through enough now.
ಇಲ್ಲ sir, merits ಮೇಲೆ hear ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ, your lordship has already accepted. He has heard on that 74.
Only on the IA. Only on the IA.
IA.
Adike, that's why I'm saying. You want, since Harshvardhan said he wants to argue the main matter, I said the best thing is to hear the main matter.
That is not a viable solution.
Because it is 2019. Adike ಸ್ವಲ್ಪ ದುಡ್ಡು ತಗೊಳ್ಳಿ. Proposal.
My lord, the other thing would be, my lord, if the AG could suggest something between, my lord, 25 and 50, lord, anything
I don't know whether you heard us. That's exactly what he's saying.
Yes,
that's exactly what he's.
But let that be uniform, my lord. Not that, lord, the smaller extent people will not take a larger amount, and my lord, larger extent people will not take lesser amount. That will not. Yes. As a percentage, my lord, if you could suggest, my lord, something on the next day.
They'll give a proposal. ಇವಾಗ ನಾವು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ ಆರ್ಡರ್ಸ್ ಮಾಡ್ಕೊಂಡು ಒಂದು what we'll do is we want to fix a date. Sir, we want to fix a date. Yes. After learned advocate general will prepare the proposal, hand it over to you. It will be communicated to you. Then both of you decide. I mean, both the officers decide which date you want the matter to be taken up. That day we'll fix it at 4:45 and we'll try to resolve this. All right. Date kodala. We'll simply say 2 weeks.
Not any tentative date because that correspondence and any date after.
ನಿಮಗೆ ಅರ್ಥನೇ ಆಗಲ್ವಲ್ರಿ ನಮಗೆ ಡೇಟ್ ಕೊಟ್ರೆ ನಾವು
ಕೋಆರ್ಡಿನೇಟ್ ಮಾಡ್ಕೊಂಡು
ನಮಗೆ ಕೋಆರ್ಡಿನೇಟ್ ಮಾಡೋದು ಕಷ್ಟ ಆಗುತ್ತೆ.
ಆಯ್ತು ಕೊಡಿ 8ನೇ ತಾರೀಕು 2:30 ಕೊಟ್ಟಿರೋಣ. 8ನೇ ತಾರೀಕು 2:30, 8th 2:30. ಓಹ್, ಅದು ಅದೇ ಪ್ರಾಬ್ಲಮ್. ದಟ್ ಪ್ರಮೋದ್ ಕಟಾವಿಸ್ ಮ್ಯಾಟರ್ ಅದು ತಗೊಂಡ್ಬಿಟ್ರೆ ಇರ್ಲಿ ಬಿಡಿ, ಅವತ್ತು ನೀವು ಇರ್ತೀರಲ್ಲ ಅವತ್ತು, ಅದಕ್ಕೆ ಅದೇ 8th 2:30, 2 weeks. Just see that. Thank you. One more thing. Supposing 2:30 agdidru kuda, for sure at 4:45 something we'll do and we'll sit.
Much.
Great.
Right. Learned Advocate General. Next matter also, Mr. Lakshminarayan has come. See, it's a small piece of land in the jail, inside the jail, jail premises. So that they are saying pay under the new act. I think this also has to be resolved in some manner. I don't know whether you've been briefed or not. Because they've challenged the acquisition itself and various grounds are urged. But I think if the compensation as per the new act is paid, better. We'll resolve it, sir. ಹೌದು. ಸೊ ಇದು 8th ಹಾಕೊಳ್ಳೋಣ, 8th ಹಾಕೊಳ್ಳೋಣ. ಅಷ್ಟೊತ್ತಿಗೆ ವಿಜಯ್ ಜಸ್ಟ್ ಬ್ರೀಫ್ ಸರ್. ರೈಟ್, 8th 2:30. ಹೊಸ ಲಿಸ್ಟ್ ಅದೇ ಇವ್ರದ್ದು ಅಮಿತ್ ಕೃಷ್ಣಮೂರ್ತಿ ಸರ್ ಇದಾರಲ್ಲ. Right. So we have heard you. Opposite side. Sir. Thank you. Sanjeev Kumar Patil. Just refresh. Mr. Oppo Reno 2F. ಯಾವ ಮ್ಯಾಟರ್ ರೀ ನಿಮ್ದು?
ಸಾರಿ ಸರ್,
ಯಾವ ಮ್ಯಾಟರ್ ನಿಮ್ದು?
ಸಾರಿ ಸರ್,
ಯಾವ ಮ್ಯಾಟರ್ ರೀ ನಿಮ್ದು? ರೈಟ್. ಅವರು ಸಂಜೀವ್ ಕುಮಾರ್ ಪಾಟೀಲ್ ಫಿಸಿಕಲ್ ಚೆನ್ನಾಗಿರೋದು. ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಕೇಳಿಸ್ತಾ? ನಿಮಗ್ ಕೇಳಿಸುತ್ತಾ ಮಾತಾಡೋದು ಆರ್ಗ್ಯುಮೆಂಟ್?
ಇಲ್ಲ, ಅವರು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
ನಿಮ್ ಕೊಲೀಗ್ ಅಟ್ಲೀಸ್ಟ್ ಯಾರು ಇದಾರ ಇಲ್ಲಿ?
Yes, my lord. I will. Otherwise, I will inform my colleague to my lord on the next date of hearing. Will argue the matter.
ನೆಕ್ಸ್ಟ್ ಸರಿ, ಅವರು ಬಂದಿದ್ದಾರೆ ಗುಲ್ಬರ್ಗಾಯಿಂದ.
Lord, because the party
ಮೈಕ್ ಕಾಣಿಸ್ತಾ ಇದೆ ಅಲ್ಲ, ಆಡಿಯೋ. ಇವರು ಸಂಜೀವ್ ಅವರು, ಸರಿ, ಅಮಿತ್ ಅವ್ರು ಕಾಣಿಸ್ತಾ ಇದಾರ ನಿಮ್ಗೆ?
No, my lord. No, he is not visible.
ನಮ್ ವಿಂಡೋ ಪಕ್ಕ ಇದೆ ನೋಡ್ರಿ, ಆ ಸ್ಕ್ರೀನ್ ಅಲ್ಲಿ ನಮ್ ವಿಂಡೋ ಇದೆಯಲ್ಲ. ಫಸ್ಟ್ ಲೆಫ್ಟ್ ಹ್ಯಾಂಡ್ ಸೈಡ್ ನೀವಿದ್ದೀರಾ, ರೈಟ್ ಹ್ಯಾಂಡ್ ಸೈಡ್ ನೀವಿದ್ದೀರಾ ತಾನೆ?
Yes, sir.
ಮಿಡ್ಲ್ ಅಲ್ಲಿ ನಾವಿದ್ದೀವಿ. ಅದ್ರ ಪಕ್ಕ ಯಾರಿರೋದು? ಅವ್ರು ಮಾಸ್ಕ್ ತೆಗಿತಾರೀ. ಇವಾಗ
ಇಲ್ಲ, ಇಲ್ಲಿ ನನ್ನ ಹತ್ರ ದಟ್ ಫೆಸಿಲಿಟಿ ಇಸ್ ನಾಟ್ ವಿಸಿಬಲ್.
ಮೊಬೈಲ್ ಇಟ್ಕೊಂಡಿದ್ದೀರೇನ್ರಿ ಸಂಜೀವ್? ಮೊಬೈಲ್, ಐಪ್ಯಾಡ್, ಸಿಸ್ಟಮ್ ಏನು?
ಇಟ್ ಈಸ್ ಮೊಬೈಲ್ ಮಿಲೋಡ್.
ಈ ಸಿಸ್ಟಮ್ ಇಲ್ವೇನ್ರಿ ನಿಮ್ ಹತ್ರ?
ಇದೆ ಸರ್, ಅದು ಸ್ವಲ್ಪ ಪ್ರಾಬ್ಲಮ್ ಬರ್ತಾ ಇದೆ. ಐ ವಿಲ್ ಮಿಲೋಡ್ ಜಸ್ಟ್ ಎ ಮಿನಿಟ್ ಮಿಲೋಡ್.
ಅದೇ, you can hear him and talk. Let him, we'll do one thing. Let him conclude. Your reply will take it up so that he can also come. That is better. Please take your seat. ಹೇಳ್ಬಿಡಿ. Right. Second one is the owner of the right. Second part, I will give you 1975. That's right. Right.
Latest say to be the wife and children of Bhimapal, different number one. Native number 5 is the second wife of Nagapal. Whereas another 20 is said to be stepsister. They have not transferred the reform setting aside of the relation. This is equal to only what
Defendants are really. The family. Oh, D1. And his mother, his wife is Janaki, his mother is Janaki. Wife of Bhima. Right. So essentially, dispute between first wife's children and second wife's children.
Relative number 5 is not the second wife of Bhima.
Yeah.
Relative number 5 is the second wife of Nagapal, the second of dependent number 1. So there is no first wife and second wife.
Let's one thing. Nagappa died in 1965. Nagappa had two wives. First wife, we don't know the name here. Second wife is Sangava. Now, these plaintiffs are the children of Bhimappa and Janaki Bai, as well as Europe. Sangav, plaintiff number 5 and 6 are. Right. Right. No difficulty. Now, share has to be given if it is ancestral property. Then share has to be given in the estate of Nagappa. Now, this Bhimappa is alive, is it? He was alive. Right. And so these people under. Correct. Issue number 1, whether the group property is property. Has been answered by this on the report in an earlier round. Right. Last time Kotru, no, we remember. Because vaguely we remember, because there are a lot of things that happened in the interim. ಇದೆಲ್ಲ ನೋಡಿದ್ನಲ್ಲ ಇದನ್ನ ಇದೆ ಈ ತರ ಒಂದು ಬಂದಿದೆ ರೈಟ್ ಜಸ್ಟಿಸ್ ಠಾಕೂರ್ ಅಂಡ್ ಶ್ರೀಧರ್ ರಾವ್ ಅಲ್ಲ ರೈಟ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ The bank was acting upon the admission of PW1. The bank was acting upon the admission of PW1 to the rest that the properties are subcontract property of the second quarter. Inheritance of the property by the first and in view of the mutation entry, I that the properties are the nature of subcontract property of the first defendant. The set finding of the trial court, in view of the law determined by the Supreme Court, appears to be improper and adverse to the success. In the absence of any value transfer into a property of two type estate, some involve transfer to provisions of two. In which event, the widow of Nagappa also would be entitled to the partition. Further, the claim made by other plaintiffs also require due and valid consideration for adjudication with the trial court, failed to address itself. That was para 14 with regard to training of the issue. So, we come to the last page, page number 15. In view of the foregoing reasons and discussions above, the appeal is remanded to the trial court for disposal according to law on issue number 2 to 8. Right. Therefore, issue number 1. So, the nature of property is concluded. The nature of property Is correct. Uttam Singh, Saubhag Singh, if it holds the field till today, then whether it is undivided interest in a co-parcel or under Section 8 makes no difference. The grandchildren will not get a right. That seems to be the position. On facts. Correct. 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 That's right. Correct. The trial court in Madhya, this appeal. Issue number 1 has been answered by number 4. Say that it is an ancestral property. We go on to answer issue number 2 to 8. Say that has been the father defendant number 1 he doesn't. Issue number 1 nalli this court said it is self-acquired property. Sorry. Then maybe I missed it. Sorry. 1 second. This court did not actually say anything. It said that the finding of a trial court and it is self-acquired property is not covered. And in that case, the bureau of Karnataka also gets right. The trial court acting upon the admission. That the properties are the self-acquired properties of the property. The inheritance of the properties by the first defendant is not established. And in view of the mutation entry, that the properties are the nature of self-acquired property. The said finding of the trial court, in view of the law laid down by the Supreme Court, appears to be improper. Shall we take it that it is concluded it is ancestral property? I would not be happy saying that it is. That's it. So it's concluded. Right. So now if we come back to the family tree, the Nagappa is a son. He predeceases Jettappa. Right. In the hands of Jettappa, it was ancestral property. As per the records, but the finding. It is ancestral in the finding. If it is ancestral in the finding, if that is the finding. I never remember last time legal necessity adala bantu. So the issue is concluded with regard to ido. Therefore, if D1 you appear for ill needs from D1, na? And Mr. Krishnamurthy appears for who appears for D1 himself, he passed away. Right. So all this controversy today may not be relevant except with regard to how to adjust equity so far as you are concerned. The question will be whether the sale, whether there is any proof that this was addicted to bank money to whatever. Right. If the sale is bona fide sale, whether for legal necessity or not. If you do not know that it is for legal necessity, the equity is to be or not is the second question. So this nature of property, all that is not really germane right now. It is not germane. So issue number 1 is not is answered. So the only other issues are there with regard to legal necessity. That is concluded. Permitted to argue this one thing, which is very important. This honorable court tells that it is not self-acquired property of Innova. Obviously, it is not self-acquired. It follows very much either of the inheritance of therefore it cannot be self-acquired. Whether the question will be whether it will be a co-parcel property or not. This question has not still been answered. What I think. It is not self-acquired on the brother, and a finding on issue number 1. Ade, plaintiffs has to be, if it is ancestral, in the one second. No, but at any rate, if Bimappa expires, okay, then the sale is earlier.
Sale is not challenged separately. The effect of the sale being not challenged by the sons of Bimappa during his lifetime.
See, Uttam versus Sobhak Singh, with due respect, committed an error in dismissing the suit. Because if X files a suit for partition against his father, during the lifetime of his father, let us say 2 sons, 1 father, 1 grandfather. Or the grandfather expires, it is ancestral in the hands of the grandfather prior to 1956. Grandfather passes away. Let us say after 1956, only 1 son. Then the father will have 1/3, 2 sons will have 1/3, 1/3. If it is ancestral coparcenary property, that's what I'm saying. If the grandfather had expired after 1956 also, and the father will have 1/3, 2 sons will have 1/3. Now the father during his lifetime, before Uttam Singh, Sobhak Singh, the 2 sons can demand and file a suit for partition. To the extent of, but their 1/3, 1/3 share got crystallized the moment they were born. Uttam Singh says that the 1/3 share of the father, since he inherited it from his father, that 1/3 share also devolves upon, I'll put it this way, if it is ancestral by remote antiquity, then the grandfather and the father, before the grandchildren were born, would have half share each. Then that half share of the grandfather and half share of the father. The half share of the grandfather would devolve because of the proviso to section 6 and come exclusively to the father. But the father's half share, the son would have a share. That is not answered. Suit is dismissed in toto. Yeah, during the father's, see, father shared, there's some discrepancy. Atara bardiyara. Right. Because our understanding was that the grandfather's half share devolves under section 6, and though it devolves under section 6, succession is under section 8, and therefore the grandchildren can't claim. You are saying the father's right by birth also they can't claim, and therefore the suit is dismissed. Summarize ಮಾಡಿದ್ದಾರೆ. We'll just read this. We'll just read it in detail. No difficulty. So, okay, that is the legal position. That means the father's half share which he got by birth, just to go forward with my example, our example. So children cannot claim. Grandfather's half share also they can't claim. So long as the father is alive, that's the end of it. That's the end of it. And this judgment was not there when Justice Thakur and Justice Sridhar Rao gave this judgment. But the fact is, we'll have to apply this. Notwithstanding, so what the argument is, notwithstanding, even assuming worst case scenario that it is ancestral property, because of Uttam Singh, Sobhak Singh, suit has to be dismissed. Suit ought to have been dismissed, even assuming if there was no alienation, demise of Bhimappa during the pendency of the suit, no difficulty. If Bhimappa had parted with everything, the suit has to be dismissed. Sanjeev Kumar. Second argument is legal necessity. We'll just read this. You want us to read Uttam Singh, Sobhak Singh? Second is legal necessity. Third argument is adjustment of equities. In that order of right. Uttam Singh, Sobhak Singh ಓದ್ತಾ ಇದ್ದಾರೆ. ಓದೋಣ ಇವಾಗ ಓದೋಣ. We can refresh ourselves. Right.
My lord, one submission before that. My lord, may I make one submission? My lord, kindly see, my lord. After the remand, the trial court kindly on issue number 1 did not give any finding, my lord. Kindly see issue number 1 on page number 8, they simply say
Yeah,
that.
if it, Sanjeev Kumar, on
Yes.
admitted facts, if they were to apply Uttam Singh, Saubhag Singh,
Yes.
then consequences will have to follow. There is no need for a remand. Even as see the trial court, as on that day in the year 2002, when the judgment was passed, simply
Yes.
followed the remand order.
Yes, my lord. They don't give any findings. They say that.
But today, if the
already-
legal position has changed,
Yes.
we can't ignore it and say or remand it just for the purpose of redoing it. It's a pure legal issue.
Yes, my lord. That's the only I want.
You can answer, no difficulty.
Yes.
Right. Full oath bidi, so that we understand the entire.
He had right by birth because that property right from all four brothers, including the latest brother, that the food property was not accessible property. And as earlier partition act, because this was the latest father had become separate. The High Court by its order dated 21st brother, between the latest food that was admitted by everyone, that the property was only accessible property. Partition of the said property as made by independent state. The first amendment provides separated by that form of money and the property was accessible. And that earlier partition to the brothers tax. However, it held that the plaintiff's grandfather was having died in 1970. It is below right now, alive at the time of his death. That Jagannath Singh is there. Who have to be distributed in accordance with as if the Jagannath Singh had died in the state. And acting the case, such a great statute. The joint family property has to be divided in accordance with the rule of justice and not survivors. This being so, all joint family property remained to be divided, but the suit for partition was by the plaintiff. And the plaintiff had no right, while his father was alive, the father alone being after there, consequent to the plaintiff of being after plaintiff had no right to sue for partition and therefore consequently the first of the water.
Right. That's right. Shall we omit this? We'll skip all this. ಅದು ಬಿಟ್ಬಿಡೋಣ. 4 ಗೊತ್ತು ನಮ್ಗೆ, 6 ಗೊತ್ತು, 8 ಗೊತ್ತು, 19 ಗೊತ್ತು. ನೋ ಡಿಫಿಕಲ್ಟಿ. ಇದು ಇಂಪಾರ್ಟೆಂಟ್. ಕರೆಕ್ಟ್. Right.
This becomes clear for the reading of the novel of the amended provision. Next important section. From our point of view,
ಅದು ಬಿಟ್ಬಿಡೋಣ ಅಲ್ವಾ? ಹೌದು, 10 ಬಿಟ್ಬಿಡೋಣ. 10 ಬಿಡಬಹುದು. ಅದೇ ಕುರ್ಪಾಡು ಬೇಡ. 11 ಬಿಡ್ಬೋದು. 11 ಬಿಡ್ಬೋದು. ಇಲ್ಲ, ಇದು ಮಾಡಿ, ಇಲ್ಲಿ ಬನ್ನಿ. 14.
it becomes clear that the death of Jagannath Singh in 1973, proviso to section 6 to apply. Jagannath Singh had just behind his blow, who was the last one equally upon the application of explanation after the transaction. Partition must be said to have been effected by operation of law immediately before the death. This being the case, it is clear that the plaintiff would be entitled to share on this partition taking place in 1973. We were informed, however, that the plaintiff was born only in 1977 and that for this reason, his birth week after his grandmother's death, obviously no such share could be allowed this share, but that is entered into an 8 share, dividing the joint family property. 8 4 shares in 1998. What was therefore, what has therefore we see is whether the application of Section 8 in 1973 on the death of the Renal to get the joint family property in acts of other uncles and the relative, no longer joint family property after the definition of the Renal by the application of Section 8 among this class of case. This question would have to be answered with reference to the
Right. This is the main thing. So this para 14 is the issue. Right. No difficulty. That also, that is. 18 ಕ್ಕೆ ಬರೋಣ. Bawar Singh Puran, correct. Correct. Bawar Singh Puran ಇದು 95 ಅನ್ಸುತ್ತಲ್ಲ? 2008, correct. That's right. Para 18. ಗೊತ್ತಾಯ್ತು. So para 14 and 18 is the ratio.
Some other judgments were cited before us for provision that joint family property continued as such even with the stones are proposed. And if the sum is gone to first the joint family property continues as such, there is no character merely by virtue of the fact that there is a stones or proposed. There are now some other virtues. I believe the owner of the side of none of these judgments would take the appellant any further, view of the fact that none of them is there any consideration of the effect of such 4, 8, and 19 to succession act. The law therefore, insofar as it applies to joint family property, governed by the reductions to prior government of 25 would therefore be summarized as follows. When a male Hindu dies after the commencement of the succession act, having at the time of his death an interest in the property, his interest in the property will devolve by survivorship of all the survivorship of the property. Proposition 1, an exception is contained in section 30, explanation of the act, making it clear that for exactly everything contained in the act, the interest of a male Hindu in becomes a property. His property that can be disposed of by him by will or other persons disposed. A second exception enacted on proposition 1 is contained in the proviso of section 6, which states that if such a male Hindu had died in female relative specified in class 1 or a male relative specified in that class, who makes too much female relative survive there, then the interest of the deceased in the property property to devolve by testament or intestate succession and not by survivors. In order to determine the share of the Hindu male property governed by section 6 proviso, partition is effected by operation of law immediately before his death. In this partition, all the properties and the male Hindu get a share in the joint family.
That's right. That's right.
On the application of section 8 of the Act, either by reason of the death of the male Hindu leaving the acquired property or by the application of section 6 proviso, such property would devolve by interest.
Correct. This is the actual ratio. This is the one.
Principles of interest. The joint family property ceases to be joint family property in the hands of the various persons who have succeeded to it as they hold the property as connection.
Section 19. And they take it per capita and not per stirpis.
Applying the law to the facts of this case, it is clear that on the record of whether or not so the joint family property which one access to property and the other co-partners evolved by succession of the succession. This being the case, the ancestral property seems to be joint family property on the date of death of the and the other co-partners and the widow held the property as tenants in common and not as joint tenants. This being the case, on the date of birth of the other in 1977, the ancestral property not being joint family
Suit for partition. Right. So now we come back to this. What it essentially means is, upon the death of Nagappa in the year 1965, in the hands of Bhimappa, it is not joint family or co-personal property. And if that is the position, notwithstanding the finding in the earlier round of litigation, even assuming that it is ancestral joint family property, applying Uttam Singh, Saubhag Singh, during the lifetime of Bhimappa, the children could not have filed a suit for partition. Alva? That is the.
But there is a possibility, is there a possibility that the property is ancestral, but still not.
That's what Uttam Singh. That's what Uttam Singh seems to say. No, it's like this. What started off like this, I think how we'll have to look at Uttam Singh is the property originally ancestral. If it devolves under section 6 proviso, the moment it devolves or upon devolution, loses the nature of ancestral. That is the category. This is a departure. What Uttam Singh changed the entire thing. This has not been touched. Show me that. 19. Yeah, copy, one copy there. Just. Anatullah Sudhakar yak hakadri. Anatullah Sudhakar yak hakadri. Declaration nu kelilla. First, we will just write off points. No finding, no positive finding. By this court prior to remand that suit scheduled properties are ancestral or co-personally. Right. Only finding is it is self-acquired property of D1. Then second, Uttam Singh case applies directly. Suit has to be dismissed. Three, no prayer for cancellation or declaration, at least. Or at least declaration. Declaration of pre-suit alienations. For legal necessity, huh? Right. Now I said pre-suit. Pre-suit alienations 5 in number. Pre-suit alienations. Then legal necessity, no evidence regarding vices. No evidence regarding D1 being addicted to vices. That way, vices may be, one is the other habits, what we call gambling, drinking and all that. The other thing could be womanizing also. Aliening, correct. Correct. Okay. Drinking and debauchery. Immoral. Right. Then last one, adjustment of equities. Right. Regarding? So estoppel and one sale deed, not all 5. That's what one property. One property. Correct. Correct. When all 5 have come from this common source and they acquiesce to one sale, it also shows that their father was the owner of the remaining 4 also. Additional evidence, sale deed in respect of item number. Item number, gotta? Item number. Oh, then may not be subsequent to suit or suit. Correct. Right. That we'll see. ಅಷ್ಟೇ ಅಲ್ಲ ಕೃಷ್ಣಮೂರ್ತಿಗಳು ಏನಾದ್ರು ಮಾಡ್ತಾರಾ? ಅದೇ ಅವ್ರು ಯಾವಾಗ ಬರ್ತಾರೆ ಇಲ್ಲ ಇವಾಗ since we have now made notes and video, shall we continue VC so far as you people are concerned? Right. Right. EW1. Neela. Janki Bai. Right. 85 days. 85. ಒಂದೇ ಪೇಪರ್ ಬುಕ್ ಇದೆ ನಾವು ಮಾಡಿಸ್ಕೊತೀವಿ ಒಂದ್ ಜರ Now, what is the admission? Right on this scene. Ah. Right. ATP. Further cross. Quarry land, Shirol. Right. Right. We'll go through it. Yavat Hakli, Sanjeev Kumar.
My lord, I'm sorry, my lord, because my my lord, any day, any date fixed, my lord, I will.
Yeah, correct. Correct. That's right. Eighth, Marana.
Yes,
Eighth
sir.
will conclude it. We should be able to conclude it. You can also come online. You'll hear Mr. Krishnamurthy on that day. We'll conclude it. Downstairs. Come and take it. Single is allowed. Bodybuilding. Keep this. Doesn't look good. Right. Right. Right.